Okay, good morning, everyone. My name is Misheal. I'm the FOLA Family Law Chair. Inherited this position from Justice Valerie Brown, who has been recently appointed. Just before I start my report, which is based on what Justice Brown and Mike Winward, our chair, has provided on previous occasions to the Law Society and working with MAG. I received an email this morning from Legal Aid Ontario indicating that they will enhance.
They can't hear you.
Is that better? Wow, now it's echoing in my ears. I received an email from Legal Aid Ontario this morning indicating that they will be providing additional family duty counsel services effective next week, November the 18th. It's a welcomed step. I think it's a closer step to what we always has harped about is access to justice. It's not a lot, but in my view, something is better than nothing. I'll move on to the report. Back in May of 2019, FOLA made submissions to the Law Society Access to Justice Committee. And some of the key points that was raised by FOLA were as follow. Access to justice, an initiative of developing family law service providers. From FOLA's perspective, certainly they appreciate the Law Society's ongoing commitment to making access to justice a priority consideration in execution of its mandate. We submitted that this commitment is absent of comprehensive strategic partnership and plan with access to justice partners such as MAG, Legal Aid Ontario, and family law practitioners. FOLA's view was that this initiative was misguided. We submitted that this does not enhance the access to legal services, and it will not promote accurate and clear legal information for the public or support an accessible, fair, and effective justice system. One of the suggestions or one of the assumptions that was made is that this plan would reduce costs, or the objectives that will reduce costs. However, from our perspective, there was no, this was not supported by any factors. It was just simply an assumption. And there was the belief that non-lawyers, licensee, would be lesser fees. Having said that, these individuals are not just going to be handed a certificate and saying, here you go, now you could practice certain areas of law. They need to be educated. There's a cost involved in this. There is liabilities, insurance, so on and so forth. All of that is added factors that there's nothing to support that if they commence practicing certain areas of family law, that it will be a modest cost to the individual. We believe that meaningful cost savings is found within the system, such as there's Justice Net, workplace benefits, private insurers, lawyers offering the reduced rate already, and there is the unbundled service. Just on the reduced rate and unbundled service, I don't believe it's official yet, but there is, my understanding, there might be a pilot project here in Toronto where certain lawyers would sign up and they would attend court on certain days and would offer their services right there on the spot for substantially reduced rate than their actual rate in their office. Nothing has to come to fruition yet, but I'll follow up on it, and certainly I'll be happy to report that on the next occasion. We also submitted that we submitted that to the Law Society that Law Society, can better address the assumed cost issues through a comprehensive strategic plan and advocacy with our access to justice partners. There's also other services that it's accessible to the public, such as the FLIC Office, the Family Law Information Centers found in courthouses. There's the Duty Council, which scaled back, but then again, this morning, the email from this morning, at least they're adding additional services. There's the lawyer referral service that offers half-an-hour free consult, and there's online resources, just Steps to Justice, and there's CLEO, that's the CLEO, not our partner CLEO. Again, there is no evidence that such service would contribute to an effective justice system. Possibility it creates confusion, and it might be a duplication of service and cost. When I say duplication of service and cost, if the individual is unable to effect or provide complete service, and then they're having to hire lawyers subsequent to that, then we're starting from scratch, essentially. We've also made submissions with respect to the Family Law Limited Scope Service Providers, or project, sorry. FOLA submitted that while the project itself, it included participation from LawPro and offer resources to both clients and practitioners, we believe that the Law Society could do more, such as supporting the Family Law Limited Scope Services, endorsing retainer agreements or precedent forms, for retainers, and provide its own directory for lawyers who offer such unbundled service. This does not exist in the Law Society website as we're speaking, not to my knowledge anyway. We've also, FOLA supports the Law Society's commitment to exploring how law students may satisfy the legal need. Justice Strathai yesterday, he emphasized on hiring or mentoring. I believe this is a great idea where student fees are significantly less. They're already assisting in family law matters under supervision by the lawyer, and the student also are well-versed and educated in other areas of law. Family law is not just simple family law, because sometimes there's a cross-path between family law, criminal law, estate law, and whatnot. So law students would be able, at least they have that connection. And again, there is no confusion as to the scope of practice that the client is receiving, and there's no potential liabilities as well. I'll move on to next. Also, FOLA submitted, or worked, not submitted, with Lindsay Park, MPP, and Parliamentary Assistant to the Attorney General, which led a review to the family and civil legislation. My understanding, they went around the province, they've met with certain associations across the province, and FOLA has made attended with these sessions and made the following submissions as well. I'll just be very brief on, there is what we've submitted with respect to appeals. We hear, Mike said that earlier, that the Court of Appeal has indicated that there is, I don't want to say a lack of knowledge, but certainly there could be some efforts made in improving the quality of it's being provided. So appeals, it's a great challenge. There has to be a procedural understanding as well with respect that it entails with it when it comes to family law appeals. Confusion about whether procedural orders made as an interim order at an interim stage, whether it's considered which court would hear the appeal. The Children Law Reform Act, we've also submitted that it needs to be updated to coincide with the new Divorce Act and the recent Children, Youth, and Family Service Act, the modernization of the Family Law Act as well. We've made submissions with respect to that. There is, in relation to the matrimonial home, it has to be changed. We've also made submissions with respect to Income Tax Act, as well as to give the courts the authority to inquire perhaps with automatic release of income information of support payers, and the automatic adjustment of child support as well, based on an annual basis, not based on in an only appropriate cases. There is Voice of the Child reports. This is a new initiative that the Office of the Children's Lawyer has been employing, and that's hiring clinicians to meet with children on limited basis or limited interviews, where they would report to the court simply just the views of the child. And finally, there is the financial disclosure. For those who practice family law, there is sometimes financial disclosure becomes a nightmare, and specifically when there is a corporation involved, whether the person has a corporation or not. So we've made submissions with respect to that. It's all in the report. I just want to touch basically on what has been submitted. Forms as well. We've made submissions that there is some forms that are redundant, and they should consider either revamping or eliminating these forms. There's Form 13A, Certificate of Financial Disclosure, that it's being hardly used. The language of the motion to change when someone needs to change a previous order. We've also made submissions that is more or less misleading. It may imply that it's a lesser process, but in fact it's the same process as commencing an application. Improving the system, how can we do so? There is technology. I can't see from use of okay, here we go. Use of technology in Ontario. I think, again, Mike may have, or Justice Strathai has indicated yesterday that our system is quite old. There need to be improvement. Early triage, directing potential litigants to alternative dispute resolution. I think this is a very important step, especially in family law, where it may eliminate the litigation process, and it directs individuals to a lesser, a more process where they both compromise and come to a resolution. To invest resources in that as well. FOLA also broadening the scope of the motions that may be brought before case conferences as well. Under that rule, they need some clarifying what is considered urgent or hardship under the rule. We've also made submissions with respect to pre-procedural motions, taking significant amount of time to court resources and delaying time to trial. And we've also made submissions with respect to online filing. I think we're in a system where technology allows us to do so. As a matter of fact, they allow to have divorce applications made online. Why can't they have the whole process be made online? And the expansion of the the dispute resolution officers program. These essentially, I take no credit for any of this. I did not do it. It was Madam Justice Brown who did all of this. Any questions? That's my report essentially. No questions? Thank you. I'll pass it on to Terry.
I see Katie just stepped out of the room, and I wanted to stand up. I hope Sam can maybe help me. I'd like to be able to stand at the podium. Thank you.
You don't have?
No.
Okay.
Here, Sam. Good morning, everyone. I'm your legal aid chair, and when I was before you at the plenary in May, I stood alone. But in light of what happened with the budget on April 11th of this year, FOLA responded very quickly, and I wish to thank all of the executive for allowing a full committee to be struck in order to address legal aid issues that, quite frankly, are plaguing the entire judicial system at this point, recognizing that many civil matters that are not funded through legal aid simply at this juncture and frankly can't find time in the courtroom. A lot of the cases moving through the court system are criminal, family law, and a lot of them are based and funded or have been historically through legal aid. I wish to recognize, before I present my report officially here, individuals who have stepped forward and joined this committee and have worked very diligently, hard. A lot of hours have gone into this issue. Jane Robertson, present. Previously, your legal aid chair came back and joined us on the committee, bringing a lot of a family law history and background and base to assist us. I can indicate, as Sam's already shared, as she then was, Valerie Brown, now Madam Justice Valerie Brown of the Ontario Court of Justice, was an active participant on this committee and again brought to us a family law background. Sam has now stepped in and has not yet had an opportunity to do a great deal of work, but I anticipate he will. Nathan Baker has also joined and brought the criminal law side along with myself. It is a situation where, as I've indicated historically, and we did have David Fields from Legal Aid, the President and Chief Executive Officer here in the past, and David McKillop, Vice President and Executive Director of Policy Research and External Relations, has also attended here previously. We have had meetings with both of those individuals. Kathleen Murphy, Director of Communications and Stakeholder Relations at Legal Aid Ontario, has also actively engaged with us, as has the current Legal Aid Board Chair now, Charles Harnack. It is a matter where the Alliance for the Sustainability of Legal Aid has also stepped up. We had meetings that were few and far between historically, and now we have increased those meetings significantly since we were last here. There were meetings held on September 8th, October 22 to be the most recent meetings, and also there were teleconferences held monitoring the federal election on September 25th, October 2, 9, and 16. FOLA participated in all of those meetings. We also participated with a very heavy month in August. On August 14th, the Honorable Doug Downey, Attorney General, struck a full day basically and permitted the various stakeholders of ASLA to have an opportunity to speak on the legal aid issues. Part of the Alliance for the Sustainability of Legal Aid, for those of you who are unaware, and I realize I don't do real estate. When the real estate people are up here, it's like Greek to me. For some of you in the room, maybe all of this is Greek to you because you're not out there practicing and trying to do private bar certificate work or legal aid clinic work. But for those of us who are working on legal aid certificates or part of the legal aid stream of service providers, I can share with you that through the Alliance for the Sustainability of Legal Aid, we joined the Association of Community Legal Clinics in Ontario. We are in good company with the Criminal Lawyers Association, the Family Lawyers Association. The Law Society of Ontario also participates. Ontario Bar Association has a representative in attendance, as does the Refugee Lawyers Association. the Advocates Society, and also the Mental Health Legal Committee, and of course, FOLA. Of great significance in coming out of these various meetings were submissions to the Attorney General that were drafted and reviewed, and everyone participated, and where there was a disagreement, elements of the correspondence were removed, so that as an alliance we could have uniformity of position, at least with the materials moving forward to the Attorney General. The submissions that we have put forward, for those of you who practice in the area, are in support of a mixed service model. Anyone who doesn't practice in the area, I've now perhaps lost you with that. What this means is we support both the clinic service side with the legal aid employees and the private bar side as well. ASLA has denoted that the private bar should continue to be labeled as the primary service provider in the area of family law and criminal law, and that is what the legislation currently reads. We have also recommended that mental health services be added into this supported model or system. ASLA has suggested strongly, from what I understand, that duty counsel be used, but be used to fill the gap in services where certificates are not available, not the other way around, as some have reported to me is the developing system in some areas of the province. Quality control issues were also addressed, and in particular, supporting an ability for legal aid. This is our recommendation, that we support the ability for legal aid to self-monitor. Legal aid should continue to be a separate entity removed from the government, but should also have now an added ability to govern in terms of removing lawyers from panels temporarily, pending remediation, or permanently. Right now, the system is one where, as those of you who practice in the area appreciate, if there's a difficulty, ultimately it's referred over to the Law Society. This would then allow legal aid to address matters internally instead. And we also were very careful to note that these should only be referenced for serious transgressions by a service provider. We furthermore encourage the engagement of lawyers in this process to develop quality assurance programs within legal aid. We, of course, encourage that the Ministry of the Attorney General continue to modernize, and in particular in the area of criminal law, as has been and is continuing to be done in the area of civil law. We naturally stressed that, quote, adequate and stable funding for legal aid is essential and must remain a priority. I can further share that on August 15th of this summer, the Legal Aid Chair, Charles Harnack, held roundtable discussions, and these dealt with Legal Aid Ontario modernization, and also dealt with the government review of the Legal Aid Services Act. Some of you in the room are aware, and some of you, even who are practitioners in the area, are unaware. I have spoke with lawyers with in excess of 40 years experience actively practicing who were unaware that the Legal Aid Services Act is under consideration for review, amendments, and changes. We are told that it is. There's a parallel stream of consultation with legal aid doing their consultation and the Ministry of the Attorney General doing theirs, the legal aid process or stream then joining in with the Attorney General and sharing information. Unfortunately, ASLA has not been able to access the legal aid recommendations to the Ministry of the Attorney General. So I cannot report on the particular legal aid position. I'm told that my time is running short, so I will try to move a little more quickly it's a passionate area, I apologize. We have a lot of concerns as well with the legislative changes, because right now it says that for legal aid, the service providers are to be lawyers. The government may very well see fit to change that and include paralegals. If that change happens, and we don't know if it will or not, if it happens at a legislative level, that will open the door for legal aid to issue certificates to paralegals. If that happens, there could be a lot of changes. The Law Society, in the letter that we were sending out to the Attorney General, wanted paralegals referenced and included. Many other groups, like the Criminal Lawyers Association, FOLA, and the OBA did not, so it was removed. But these are the times of change that we are living in right now. Since my report, not included in my report, is the email that came out yesterday referencing changes through legal aid to family law that was briefly touched. If you received that, I stress that you read it. I won't go into the details. I can also advise that there was a teleconference that Katie and I attended with Kathleen Murphy at Legal Aid Ontario, and that was on November 6th. And that dealt with the practical day-to-day operations. And what I'm getting at is that legal aid is consulting with us. Legal aid is reaching out to us now. There's a lot more collegiality than there has been perhaps historically. There's a lot more engagement. And what we need, I need, my committee needs, the executive of FOLA need, if we are going to represent your interests, is to hear from you. We need you to reach out, speak to any of the executive members. And if you're speaking at a level that they're not comprehending, they'll send you to one of the board members or reach out to one of the members that I thanked at the beginning. We're all open to hear from you, and we want to hear from you. And we want to help in this day and age of change to make sure that the change is in a positive direction for lawyers. This is recognized at all levels. We heard this from Chief Justice Strathy yesterday, the reference to legal aid. Everyone's well aware of the issues. The question mark is, where are the solutions? And you are part of the solution, but we need to hear from you, please and thank you. Sorry to wrap it up. I don't know if there's time for questions, but we're moving into a break right now, so if you have any questions, please feel free to speak with me. Thank you.